Wilson versus the state of Florida. You may proceed.
Good morning. May it please the court. My name is Ron Johnson. I represent the petitioner, Ned Wilson. The issue in this case is whether and to what extent a trial court's denial of a motion for downward departures are reviewable on direct appeal. The District Court of Appeal ruled that a denial is only reviewable if the trial court misapprehends its discretion or refuses to exercise it as a matter of general policy. This created direct conflict with other district courts of appeal and held that a denial is reviewable under the two-tiered standard of review established by this court in Banks v. State.
Counsel, could I kind of direct and ask a question just right off the bat?
Yes, ma'am.
Assuming that we agree with you that Banks applies to denials of a downward departure as well as granting a downward departure, which I think there's some argument about whether Banks applies to both, but assuming that we think that it does. Mr. Wilson pled, correct?
Right.
And so there's a very limited amount of things that can be appealed when you plea. What category do you think that this falls under?
Well, if you're asking me, he thinks he has to reserve some issue to appeal. I mean, this is a sentencing issue, and I think
this would be, you're claiming that this is a sentencing error.
Well, I think it's fundamental error. I think it's a denial of due process, and I do think it's fundamental error. I mean, I think under the rules of appellate procedure and the rules for appeals, illegal sentences can be appealed. And I think it falls in that category.
What's the fundamental error that was committed at sentencing?
Well, Banks says that the court must go through a two-part weighing process. First, whether there is sufficient evidence to establish that a departure may be warranted. And then second, whether the court's going to exercise its discretion or not. In this case, the court did not do any weighing process, didn't even recognize that the issue had been raised, so we submit
Well, we don't really know that.
Pardon?
I mean, we don't know that the court was not just silently dealing with that and jumping to what he thought was ultimately dispositive. I mean, you're assuming that the court hasn't considered anything that the court didn't talk about. And I just think that is, I don't see why that's warranted. I also don't see why whatever you're complaining about here could not have been raised in a 3800B. What am I missing?
Because the case law and the commentary to the rules say if it was raised during the sentencing process, it doesn't have to be raised in a 3.800.
You didn't raise the error. You never pointed it out to the court that what about this? I understand you had what you presented, but you never apprised the court of what you thought was the court's the failure of what the court was doing. Am I correct about that?
We did not raise an objection in a 3.800. We did not say, Judge or committee.
But at the hearing, you didn't say to the judge, well, what about this? You didn't point it out to the judge. If you thought he was omitting something, you didn't bring that to his attention. But
we raised the issue, and Banks says that the court must determine if there's sufficient evidence to establish a mitigating circumstance and then make their ruling.
Well, and here I think what the Chief and I are both asking you, when we're sort of getting at what is the fundamental error, it sounds like what you're arguing is that the fundamental error committed by the sentencing court was its failure to make a record of each basis upon which a downward departure was sought. Is your position before this court that that constitutes fundamental error? That is, error that reaches down into the roots of the proceeding and renders its result unreasonable for us to rely upon?
I think it does when we look at Banks, and Banks says the court must evaluate the sufficiency of the evidence. And the court made no finding at all.
The absence of a record on that, your position then is fundamental error. Okay.
Right.
Counsel, let me ask you about something. I don't know that this helps you much, but in this case, the district court dismissed this appeal.
Right.
Right. Now, now whether you win or lose, I'm struggling with why it would be dismissed.
They dismissed it because they said the appeal was not authorized because there's no statutory basis for it.
Well, but we got to have a constitution that authorizes all appeals to the, let's see here, it says district courts of appeal, this is in section 4, B1 of Article 5. And maybe I'm missing something here. Maybe there's some reason this is irrelevant. But it says district courts of appeal shall have jurisdiction to hear appeals that may be taken as a matter of right from final judgments or orders of trial courts. Now, it's clear we've understood that the legislature, there's certain things the legislature can do in terms of requiring preservation, okay? They can set up some requirements that you've got to meet before you're going to win on appeal. But does the legislature have the authority to just say, well, that what the Constitution says here, and this is a final order, right?
Yes, sir.
Okay? When it says, the Constitution says that appeals may be taken as a matter of right, can the legislature dispense with that?
Will you ask me that one more time? I'm sorry, I was looking at something, Your Honor.
Can the legislature dispense with the provision that appeals from final orders may be taken as a matter of right? Now, I'm not talking about whether the legislature can do things that are going to affect whether they win on appeal.
I don't think the legislature has any authority to take a preliminary right of an appeal. I think that's a constitutional right that the criminal defendant is entitled to. And I think this court has handled, recognized that before in Davis and also in...
And I think in your reply brief, you referred to that provision. Yes. Yeah.
Part of the answer might hinge on the significance of the punctuation in this very artfully worded sentence here in the Constitution.
Pardon, sir?
No, it's just a question of whether they're talking about appeals that the legislature has authorized as a matter of right, as opposed to saying that appeals by definition in the Constitution are there as a matter of right.
Well, I think there is a constitutional right to the appeal.
If you understand the punctuation one way, then the legislature could do away with any right of appeal, correct?
I don't think they have the right to abolish the right.
I understand that's not the way, but if you got that alternative, it either is it's a constitutional right or it's a right that the legislature determines whether you have it or not.
That's correct.
And so, which means that they could do away with any right of appeal for final orders, correct?
Yeah, I think that is true.
That way.
But the legislature has determined in the appellate rights that they can appeal any sentence that is illegal. And then according to the rule, that's anything that's illegal or unlawful. And so I think that's what authorizes this appeal.
But that doesn't fall in a category when they plea. That's not an authorized direct appeal after a plea.
Well, it's part of the rule in the statute, but when you plead, you give up all rights preceding that plea. But I don't know how we could anticipate that the court might impose an illegal or unlawful sentence to reserve something at that point, to be anticipatory.
But if you enter a plea, let's say you enter a plea, and there is a sentence given. I mean, that's that's correct. I don't think that you don't have the ability to, correct?
No, I think you do. I mean, I don't think you can reserve the right to appeal a sentence that hadn't been imposed when you enter a plea. You're reserving all the rights of everything that's happened up until that point in time. You know, whether it's search and seizure issues or voluntariness issues or a confession, you can't raise those unless you reserve a right to a previously filed motion. But I know of no way, and I've been doing this a long time, to reserve a right to impose a sentencing issue that hasn't even derived. I mean,
I'm just reading the rule here. It says, this is what you may appeal: a lower tribunal's lack of subject matter jurisdiction, a violation of the plea agreement if preserved, an involuntary plea if preserved, a sentencing error if preserved, or as otherwise provided by law. This is 9.140B2A subsection I.
yes, and B1E also says you can appeal an unlawful or illegal sentence. And then 2E says anything that's otherwise provided by law.
Even after a plea.
After a plea. This is all sentencing issues. And we think the issue was adequately raised. We brought it to the court's attention. It was never addressed. There's no indication there was not sufficient evidence. The court did have the right to deny our request for down departure, but they never even discussed it. And Banks says they must assess the adequacy or the sufficiency of that evidence, and that wasn't done. And I think based upon the statute and the rule of appellate procedure, we have a right to appeal that issue. Thank you.
Welcome back.
Thank you, Mr. Chief Justice, and may it please the court to see all of you again so soon. The state believes it's plain that because Mr. Wilson entered a plea in this case, the only path to jurisdiction for him is to convince this court that the error of which he complains is a preserved sentencing error under B2. There seems to be some disagreement. Mr. Wilson seems to think he may still be able to travel under B1, but the text is quite clear that B1 governs the appellate rights of criminal defendants post-verdict, and B2 governs the appellate rights of criminal defendants post-plea. And since Mr. Wilson accepted a plea in this case, he has limited appellate rights.
And you're talking about in terms of actual jurisdiction, as opposed to whether he's got an issue that is going to give him any prospect for relief. But so what do you? How do you interpret that provision in the Constitution that I was quoting? Do you think that when it says district courts of appeal, district courts of appeal shall have jurisdiction to hear appeals that may be taken as a matter of right, that phrase that may be taken as a matter of right essentially is equivalent as determined by general law?
No, Your Honor. I do not believe that that's the way. Well, actually, I'd like to recant that statement, if I may.
So you do think?
The state is not prepared to take a position today on the scope of the protections afforded by the Constitution to a criminal defendant regarding his right to appeal. But in this court's amendments to decision, you made clear that by entering a plea, you have waived some of the constitutional protections, except for those enumerated by this court in Robinson. And there also is language in amendments to that the legislature can place reasonable restrictions upon the constitutional right of a defendant to have his appeal heard. But we
But
do
it's,
not
you
know.
If we get a case, or if a district court, let's go there. If a district court gets a case, issues raised, a one-issue case, and they determine that wasn't preserved, and it's not fundamental, you lose. They don't dismiss the case, do they? They just say affirmed, not dismissed. Am I missing something there? I mean, again, maybe I'm wrong. I just, from all my experience on the district court, when we had cases with unpreserved error, we affirmed. We did not dismiss.
I believe the reason that the lower court dismissed here was because there was no jurisdiction.
Well, I understand. That implies that. But I guess that's the question. The absence of a preserved issue ordinarily does not divest the court of jurisdiction. It may mean the court is, in the exercise of its jurisdiction, is going to be constrained to affirm, but it doesn't divest the court of jurisdiction.
And normally, that is the case, but preservation requirements can be mandatory, as this court recently recognized in Dortch. And
Counsel, could I clarify, maybe this kind of would help the answer to this question. It seemed like the first DCA was not necessarily dismissing based on a lack of preservation issue, but rather they were dismissing, saying they did not have any ability to review the denial of a downward departure. Is that kind of your understanding of why they dismissed versus just affirmed for lack of preservation?
yes, that is correct. Thank you, Justice, for reminding me. The lower court interpreted Mr. Wilson's claim a little bit differently than the state does. It interpreted Mr. Wilson's claim as saying, basically challenging the sentencing judge's decision not to exercise her discretion to issue a downward departure.
And does the state take the position that the reasoning of that decision was correct, that the district court does not have the ability to review the denial of a downward departure at all? Which I believe is what, the first DCA gave two exceptions, which is, they refuse to even consider it as a matter of policy, or they misunderstand the scope or the element. But other than that, what the first DCA seemed to say is that they couldn't review anything else at all related to the denial of a downward departure. But it doesn't appear that the state has necessarily promoted that as a reason for us to affirm. And I just wondered if there was a position there.
Oh, the state has not taken a position on this question because Mr. Wilson's case doesn't present it, and also the first district court just decided this under B1 instead of under B2, and for that reason, we can't claim to know or take a position on whether what they would have done under B2 would have been correct.
But the concern that the chief raised is getting it down to simple terms, that had the district court had just ruled affirmed, instead of dismiss, we probably wouldn't be having this conversation right now.
Yes, yes. I believe that is accurate.
Let me make sure I understand the procedural posture of the DCA below. At the in the opinion, the court says we conclude a defendant may not appeal an order denying a motion for a downward departure, and then it goes on from there. So was the appeal below of a final judgment after sentencing, or did they actually attempt to appeal an order separate from the final judgment?
No, it was solely of the court's sentence. The sentence that was issued.
A final judgment after sentencing. It wasn't a separate order of denial of a downward departure.
No, there was no separate order.
Okay.
It was just the sentence itself. It's a challenge to the in-range sentence itself, which generally is unreviewable under long-standing precedent from this court.
Okay, so in the opinion below, that when they say an order denying a downward departure, they're really talking about in conjunction with the final sentencing that took place and entering of the final judgment.
Yes, exactly.
Okay, thank you.
If there are no further questions from this court, I think that we're prepared to rest on our briefing. Thank you so much for your time.
There's no requirement to take all the time.
Sometimes encouraged.
Rebuttal.
Justice Polson, in this case, there are actually two grounds for departure. One was an isolated incident. It was sophisticated, and he was remorseful. And the court did specifically deny that request for a downward departure.
In a separate order?
Not in a separate order, or maybe a separate order. It was a ruling on the record.
I mean, it would seem to make difference if the DCA was looking at some order denying departure the way they described it in the opinion that's separate from a final judgment. That would have a lot more credibility that said, okay, we're not taking jurisdiction over this because it wouldn't fit in the parameters of the constitutional language that the chief was talking about.
Yeah, there was no written order. I had made a request for down departure in writing before sentencing and submitted a substantial amount of material, but that was not ruled on and not addressed during the sentencing proceeding.
But but sentence was imposed.
A sentence was imposed.
That's what's on appeal.
And that's what we're appealing. And I think we do have the authority to appeal that, Your Honor, based upon this court's precedents that any sentence that's illegal can be imposed. Also, the commentary to 3.800 says if it's previously been addressed to the trial court, it doesn't have to be raised in a 3.800 motion. So, I mean, I think the issue is preserved, and it's for this court to decide if it's a illegal or unlawful sentence based upon the holding of banks. Thank you.
All right. Well, we thank you both for your arguments. That is the final case on the docket today, so the court will now stand adjourned.
All rise.